Good afternoon, judging panel. My name is Manny Lima, and I'm representing Hytema and the United Kingdom, and I will be providing an expert testimony for the Five Eye Nations. My team and I have been instructed to answer these 5 questions asked by the judging panel for this testimony. Question 1. What are the legal challenges associated with cyber incidents involving foreign countries? How do internal laws affect e-discovery? Foreign legal issues including different international security rules, the absence of legislation or agreements, and law disputes. International cyber treaties encourage international collaboration. It enables governments to work together to investigate and combat cyber threats. The lack of legislation or agreements on key areas of cyber incident response concerns might jeopardize international collaboration, even within the same country. The laws, rules, policies, and procedures governing cyber events and mitigation techniques differ by nation. Everything must be taken into account when dealing with international cyber events: the location of the attack, the scale of the assault, and the legal repercussions of the attack. Even though legislation is administered on a national level or international litigation, problems exist, primarily over the definitions and concepts of cybercrime. A particular occurrence may be considered a cybercrime in one nation but not in the other, resulting in differences in relevant legislation. The physical location of electronic data sought in e-discovery might be challenging to determine due to the rising usage of numerous forms of online storage. Information communicated electronically via an email or text message can go through any number of phone lines, routers, and servers throughout the world, making establishing the location of a message pretty much impossible. As a result, it might be difficult to determine which country's e-discovery rules should be implemented, let alone how to carry them out. Each nation has its own rules and regulations governing electronic data and discovery techniques, so it's critical to understand the legislation in the relevant countries and, where necessary, to take steps to contact the right authorities before proceeding. Discovery procedures that are widespread and lawful in the United Kingdom might be deemed a criminal violation in other countries. Thus, it is vital to be aware of the laws and rules that your nation may be subject to. Question 2. What are the legal challenges of accessing and retrieving electronic evidence stored in foreign soil? Assuming cloud storage was used, what procedures were followed to access and retrieve digital evidence stored in the cloud? Accessing and retrieving electronic data during an ongoing investigation that involves international entities can be a significant challenge. When collecting evidence from foreign nations, legal challenges will arise. These include the following: international cybersecurity laws governing data sharing, data locations, international evidence handling procedures, international investigation collaboration, cooperation between service providers and law enforcement, and legal implications formed among each country. To access and recover digital evidence stored in the cloud, a country can either seek direct access from the cloud service provider hosting the data or collaborate with the country or countries in which the cloud service provider resides. After granting access, an image of the data and its location may be produced for an examination. All data gathered must be documented in a chain of custody document. To summarize, all laws and regulations of the country storing the data must be followed. Data stored in a cloud can be spread over different countries, and original data owners must be set the rules for each specific storage access. Question 3. Specific to the country that your team was assigned, How did the international laws and jurisdictions influence the process and procedures followed during the forensic investigation? When conducting forensic investigations, the United Kingdom government followed the following laws. The Data Protection Act of 2018 covers general processing of personal data in the UK. The EU-UK Trade and Cooperation Agreement of 2020, which amongst other things includes provisions which allows data transfers from the EEA to the UK to continue unrestricted for an interim period. Data Protection Charges and Information Regulations of 2018 sets out the circumstances in which controllers are required to pay a charge and provide information to the Information Commissioner. The Privacy and Electronic Communications Regulations of 2003 covers requirements for electronic communication networks and services. Question 4. What conflicts arose between the ethics and international laws during the forensic investigations? How did these conflicts affect the investigations? How were the conflicts mitigated/resolved? An individual's right to privacy is one area of digital forensics which is still largely undecided by courts. The U.S. Electronic Communications Privacy Act places limitations on the ability of law enforcement or civil investigators to intercept and access evidence. The Act makes a distinction between stored communication and transmitted communication. Article 5 of the European Convention on Human Rights asserts similar privacy limitations to the ECPA and limits the processing and sharing of personal data both within the EU and with the external countries. The ability of UK law enforcement to conduct digital forensic investigations is legislated by the Regulation of Investigatory Powers Act. In the UK, the same laws covering computer crime can also affect forensic investigators. The 1990 Computer Misuse Act legislates against the unauthorized access to computer material. This is a particular concern for civil investigators who have more limitations than law enforcement. At last, question 5. What steps were taken to protect the United States soil and citizens during the international investigation? To safeguard the U.S. during international investigations, the UK guarantees that any hacked systems will be separated from the network to prevent future infiltration. We also verify that all evidence obtained from cyber events is correctly handled through a chain of custody paperwork and that all physical security of evidence is dealt with in accordance with American laws governing digital evidence as well as international laws and standards. This concludes the testimony hearing regarding these questions. If you have any additional questions, please let us know. If not, thank you for listening.